Deputy Speaker.
The Attorney General.
Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Repeal and Replace the Crown Suits Limitation Ordinance be now read a second time. Mr. Deputy Speaker, it's now 10 o'clock p.m. We started at 10 o'clock a.m. and we're now on our third bill for the day. And I propose to give as succinct a presentation on this bill as is possible, and I expect that I will not be using my full time on this debate. By saying that, I don't want to diminish the importance of the subject matter. The State Suits Limitation No. 2 Bill 2017 is the last bit of legislation associated with what we refer to as the land package. The land package on this particular Parliament's agenda involves the registration to land title bill. It involves the land adjudication bill. It involves the land tribunal bill. And coming out of the amendments that we picked up in the process of looking to operationalize that land package, it was observed that the State Suits Limitation Ordinance was in need of attention, and specifically so for two reasons. Firstly, to modernize that piece of law, and secondly, to provide for certain categories of land that ought to be protected. The subject matter that we're treating with is the most important aspect of Trinidad and Tobago's wealth. It, of course, is the state land. In treating with state land, we are dealing with the lands of Trinidad and Tobago, and as the term land is defined at law, it includes all things that sit beneath the land in particular. It is therefore important as it relates to resources, as it relates to oil and mineral rights and exploitation, because the ownership of minerals and precious metals, etc., that sit below the land is, of course, of significant worth, as we well know as a hydrocarbon-producing country. Mr. Deputy Speaker, this State Lands Act and the amendment that we propose to the ordinance has significant history, but has very real connection to the provisions that we debated in bills earlier. When we look to what Trinidad and Tobago has by way of issues, it is definitely a situation in Trinidad and Tobago where the concept of informal settlement, as it's properly called, squatting on state lands, is a significant issue for our country. In fact, the Minister of Housing and Urban Development, the Honourable Member for San Fernando East, is well in tow with the data. Honourable members opposite will know that Trinidad and Tobago anecdotally is treating with approximately 250,000 people in squatting conditions. The very large part of squatting conditions in our country is, of course, centered upon state land. And when we look to what the law says as to state lands, this bill, in treating with the Parent Act in terms of a repeal and replace, becomes relevant. Why? Adverse possession is exactly correlated against statutory prescription periods. Let me explain that. The principle in law is that people who occupy and enjoy uninterrupted possession of land, in this case state land, for a period of 30 years and beyond, they ought to, because they've been in uninterrupted possession, they ought to be given the benefit of the title to that land. That's the law. the correlation is that the state must have some point in time beyond which it should not have the liberty to come and put people off of the land. Because if you didn't do anything about your rights as a state for 30 years, the philosophy in law in coming up with a number, a statutory prescription period, and in this case the number is 30 years, that number is the marker where we say beyond 30 years, the state has now extinguished its rights to disturb your possession. It's perhaps very well correlated to the concept of a generation. After all, generations were counted in 40 years. A generation is essentially counted as 40 years. And the prescriptive period of 40 years for the life of a human being related to land. In fact, Mr. Deputy President, when we look to, forgive me, I'm confusing the houses. In fact, Mr. Deputy Speaker, when we look to what the existing law is, we come back down to something referred to as an ordinance for quieting possession and titles against the Crown in this colony. It is headed as the Crown Suits Limitation. It is number 5 of 1898. That's 1 year before Tobago came lawfully into the adoption of Trinidad and Tobago. On the 28th of March in 1898, this ordinance became part of the laws of Trinidad and Tobago. And listen to this as we get some history off of the wording of the ordinance itself. The ordinance is signed by Governor Hubert E. H. Jerningham on the 20th of April, 1898. And essentially, the ordinance is comprised of a few sections only. There are 4 sections. It is signed by the Clerk of the Council, S.W. Naggs. And when we look to what the law actually says, the 1898 law, it is considered expedient to make provision for the quieting possessions and titles against the Crown and against grantees of the Crown and their successors in estate in this colony. And it was proposed that it be enacted by Governor of Trinidad and Tobago with the advice and consent of the Legislative Council that this Crown Suits Limitation Ordinance come into law. In this Crown Suits Ordinance, we had some very archaic language. So the law as it's currently standing is written in archaic language. I'll give you some of the wording. In section 3 of the ordinance, the Queen's Majesty, her heirs and successors, shall not at any time hereafter sue, impeach, question, or impede any person or persons for or in any wise concerning any land, tenement, rents, or hereditaments whatsoever, or such person or persons, or his, or their, or any of their ancestors or predecessors, or those from, by or under whom they do or shall claim, have or shall have held, or enjoyed or taken the rents, revenues, issues or profits thereof, by the space of 40 years next before the filing, issuance, or commencing of every such action, bill, plaint, information, or other suit or proceeding, as shall at any time or times hereafter be filed, issued, or commenced for recovering the same, or in respect thereof. Provided always that nothing herein before contained shall be construed to prevent the Crown or any person claiming through the Crown by subsequent grant from showing, S-H-E-W-I-N-G as it's spelled, in any information or intrusion or action for possession or to the established title in the Crown or in the grantee under such grant by reason of the cessor, expiration or determination within 16 years before the filing of such information or commencement of such action of the interest of any grantee under a previous grant by virtue of which any person has been in possession for 40 years or more, but the estate or interest under which within such 16 years ceased, expired, or been determined. I've taken the time to read those 2 sentences out, believe it or not, to demonstrate not only the antiquity, but the complexity of interpretation that practitioners and courts are asked to exercise in construing or understanding what the law actually says. That literally was 2 sentences divided as 2 paragraphs. And it runs afoul of the natural progression in law to use plain and ordinary English to communicate the legitimate aim of the Parliament. The bill before us, therefore, proposes that we enact the law in simpler terms, that we specifically enact Section 2 of the ordinance in modern language to limit the state's right of action against a person who has been in occupation of state land for more than 30 years. I read out the old ordinance in its original text, which was a prescriptive period of 40 years. That was amended to 30 years. And that's one of the first purposes that we do. We propose in this bill that the clause goes on. We propose that a clause go on, and I'll correct that in just a moment, Prime Minister, to allow a person claiming through subsequent grant through the state within 16 years of expiration of the grant to file or commence an action to show title in the state or in the grantee who was in possession of the previous grant some 30 years before and prior. And the Honourable Prime Minister, the historian and well-lettered and learned man that he is saying that a generation is always 20 years. And therefore, my reference to 40 years is in fact 2 generations. And what I really should have said was 2 score, as it really should have been, as we hear 4 score and 10 or other expressions in older English. So thank you, Honourable Prime Minister, for sitting with me through this purpose. The point is that, Mr. Deputy Speaker, when we treat with the prescriptive period, the first observation is that the adverse possession set out in simple English here is that if you're on state land for more than 30 years, you will have the ability to treat with the state land and claim for adverse possession. Under the package of laws that we treat with, we're moving that into the adjudication cycle under the Land Adjudication Bill, under the existing Real Property Ordinance, now Real Property Act, that is the Act of 1892, as it was originally put in. Under Part 4 of that ordinance or act, there's the ability to seek a vesting order to bring lands under the provisions of the Real Property Act to allow for adverse possession to bite. The second part that I referred to is that if your grant has expired, you had a first grant for 30 years. The prescriptive period after that is that you have 16 years to seek to bring it back under your name or bring it back under the state. So that second aspect of what I referred to by way of amendment is to treat with the expiration of an initial grant, which has now expired. Your 30 years passed. You have 16 years to rectify that situation. Mr. Deputy Speaker, Clause 3 of the bill prohibits the application of the Act to lands which are, 1, declared to be protected areas or forest reserves under the Forest Act. That's Chapter 6601. 2, lands which are declared to be environmentally sensitive under the Environmental Management Act, Chapter 3505. And 3, lands identified by the state for public purpose. And that, of course, fits within the very construct that we put forward to the Honourable Parliament in the land package, in particular the Land Adjudication Bill, where we have said in Section 4 of the Parent Act, as it is to be amended by Clause 4 of that bill, that we should have exceptional purpose for these types of lands, so that people who are on those lands will not obtain state title. And that goes to how you manage scarce resources within your country, in particular your aquifers and your environmentally sensitive areas, as we are bound to do so, not only by pure common sense and survival, lest we pollute our aquifers, but also in meeting with our obligations under the Paris Convention, which of course the country has signed and since ratified, and the obligations under the Paris Convention to seek to have the greening of our space, economy, and country preserved in appropriate circumstances. Clause 4 of the bill will seek to reenact Section 3 of the ordinance in similar terms to the ordinance, just in modern language. Clause 5 would save existing rights and proceedings commenced under the ordinance, so that we contemplate the transitional arrangements. Clause 6 would quite simply just repeal the Crown Suits Limitation Ordinance. The legislation is essentially a replication of the old law in modern language, we add the exception for the purposes described, public purpose, EMA, and also the environmentally, declared areas for forest reserves. We recommend that this is something that is opposite to the best interests of the people of Trinidad and Tobago. We think that there's a legitimate aim in simplifying the law. We think that there's a legitimate aim in providing for state protection of certain sensitive assets as a nation which we hold, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Repeal and Replace the Crown Suites Limitation Ordinance be now read a second time. Member for Couva North.
Thank you. Thank you, Mr. Deputy Speaker. We are at a very late hour here tonight, and therefore I don't intend to be too long, but to highlight that I have issues with Section 3 of the Crown Suites Limitation Ordinance and Section 4. And I will try to be as clear as possible so that the Attorney General can clarify these issues that I'm going to raise. Now, Mr. Deputy Speaker, I want to deal with Section 3 first by stating that this particular section somewhat has contradicted itself by the way the AG has explained it and by the way it's probably the language is put into this bill. And I want to make reference to how the government has acted with respect to the forest reserve and the ongoing works of this highway. And I just want to quote with respect to the Act. This Act shall not apply to land declared to be a protected area or forest reserve under the Forest Act, declared to be environmentally sensitive under the EMA Act, and identified by the state for a public purpose. Mr. Deputy Speaker, the AG just mentioned about putting the Paris Agreement at the forefront and, of course, being an advocate and being a signatory onto this, the mitigating the effects of climate change and all of that, and supporting that thrust, this global trust that we have. But, Mr. Speaker, I want to ask, Mr. Deputy Speaker, I want to ask, for those of us who are not aware, and I make reference to the Komoto-Manzanilla Highway and the issue with the Aripo savannas and that forest reserve, let me clarify to begin with. There are 10 discrete areas, Mr. Deputy Speaker, comprising the Aripo savannas. In 1934, the long stretch forest, it was called, consists of the Aripo savanna and was proclaimed a reserve in 1980. The area was proposed as a scientific reserve in 1987, according to the EMA website. So the Aripo savanna is just not one designated area. It is a series of savanna that comprise the Aripo savanna that is interspersed between this long stretch of forest reserve. I also want to highlight, Mr. Deputy Speaker, that in this study that was done by Mr. Linton Arno, and it's titled Komoto-Toko Highway Project, is it a mortal blow to our ecosystem? And it was published in the UE Today, November 2017 article. And the recommendations that were given were that even though the engineers have implemented a 100...
Speaker, Standing Order 48-1, please.
What? No, I'm dealing with Section 3.
Members. Come on. Overruled. Proceed.
Thank you. Thank you, Mr. Deputy Speaker. Again, Mr. Deputy Speaker, just to reiterate, I'm dealing with Section 3 of the Act, Clause 3, sorry, of the Act, A, B, and C, where state title cannot be obtained for Part A, areas declared to be a protected area or forest reserve under the Forest Act. Part B, declared to be environmentally sensitive. And Part C, state for a public purpose. And I'm just putting these issues forward for some clarification. So I am, Mr. Deputy Speaker, making reference to a study done by Mr. Linton Honor. And he's saying, and the government has given this information, it's public knowledge, that between the Aripo Savannas and the Komoto to Manzalina Highway, there's a 100-meter buffer zone. All right, the 100-meter buffer zone. So it's not very far. The highway is not very far from the Aripo Savannas. A recommendation was made stating that there should be a 200-meter buffer zone and or an alternate route be proposed.
Standing Order 48-1, please. How long should you stay on closed street?
I am...
Listen, Leader of the House, with specific reference to?
Mr. Deputy Speaker, in the last debate, we dealt with the issue of the Aripo Savannah and the so-called buffer zone and so on. Yes, we did. And Mr. Deputy Speaker, we are talking specifically about the Crown suits, and if I may go to the bill. If you want me to go to the bill?
Okay, I understand the point. Okay. I will make a ruling. Okay. I must make a ruling. Member, proceed. But again, in the interest of time.
Yes.
Right, and the late hour, let's come to the point, please.
Yes, Mr. Deputy Speaker. So, Mr. Deputy Speaker, I'm referring to the bill and I'm asking the Attorney General to clarify if you're saying that state title is not to be given because of these conditionalities in Clause 3.
Specifically that this bill does not apply to protected areas. And since it does not apply, we can't debate it.
Precisely.
It's totally irrelevant. It does not apply.
Member, move on to another point.
Thank you, Mr. Deputy Speaker. So, Mr. Deputy Speaker,
time will continue to elapse. So please, let's keep it tight.
All right, Mr. Deputy Speaker.
Come to the point.
Right, so this was just an issue that I wanted to raise and highlight since it is, of course, part of the bill. It does not apply as the goodly AG and the minister, the member for Diego Martin Norty says it does not apply. But I want to raise the issue because it is in the bill. It falls under the ambit.
Deputy Speaker, 48.1, Clause 3 is clear. The Act shall not apply to protected areas.
I'll move on.
I'll say that.
I just ruled.
Mr. Deputy Speaker, I've made my point.
I just ruled.
And I will move on. All right, I will move on. I've given the recommendation. It's on the record. And it's up to the AG to refer and probably explain later on. Now, Mr. Deputy Speaker, I want to move on to Section 4. And Section 4 deals, of course, Clause 4, sorry, deals, of course, with that of adverse possession.
Minister of Finance and Naparima, please proceed.
It deals with that of adverse possession and, of course, squatter rights, rules and regulations. Now, Mr. Deputy Speaker, I personally think that putting the burden of proof on the defendant can be seen as harsh and onerous. I saw here in Clause 4 that of the onus of proof on state after 16 years possession by the defendant. So the Attorney General made reference to that. But, Mr. Speaker, we know what really takes place and what is the reality on the ground with respect to deeds at the Land Registry Department. And I want to ask the Attorney General that it is no secret that person deeds go missing at the Land Registry Department. And when such a burden is put on a person to show that he or she has a right on the property that he or she is living on, and the AG's office can't support it, what happens then? Can't support that evidence. What happens then? Is the person removed from the land? Is the person supposed to be removed from the land at that point in time? So, Mr. Deputy Speaker, what I'm trying to get at is that the issue of adverse possession must look at the ways in which a person adversely possesses the land. That is by factual possession, which signifies an appropriate degree of physical control. The occupier must take control of the land and must make use of the land in full and open to the public, and without interference from anyone. Some acts that may show adverse possession are building on the land, fencing the land, living on the land, planting on the land. And the more things that are done on the land, the more convincing the case for adverse possession. So, Mr. Deputy Speaker, this particular section that deals with that, I don't think that the capacity that is needed to regularize those persons, squatting especially on state land, is present at this point in time. I also don't think that the state has the resources at this point in time to enable the ministry and the agencies to deal with this in a very efficient and effective manner. And therefore, Mr. Deputy Speaker, I think this issue of squatting, and the AG just mentioned that there are over 200 persons, AG, if I'm not mistaken, 250,000 persons squatting on state lands. Now, Mr. Deputy Speaker, as a member of Parliament, in all of our constituencies, there are pockets of squatters. And some would tell you in these areas, they have gotten letters of comfort over the years. They've been there for a number of years. They've applied for the land. They've been given an interim letter of comfort so that they can take to the bank and that sort of thing. They've been able to get electricity, get water in some areas, even where they have not been given letters of comfort. And Mr. Deputy Speaker, there's a clear disconnect between what we are trying to achieve here tonight in terms of regularizing and dealing with squatting and what actually is taking place and has taken place on the ground with respect to some of these squatter communities. Mr. Deputy Speaker, you'd be surprised to know that if you drive through some of these squatting communities, there are more amenities and luxuries that you would see in some of these areas than you would expect. Mr. Deputy Speaker, I don't know how the AG intends to deal with those persons who have been there for so many years, have not been able to get legal title, and then all of a sudden we have this suite of legislation, this land package coming in. It would take a number of years, Mr. Deputy Speaker, really to get these legal titles out and to get the squatting problem under control. Now, Mr. Deputy Speaker, as I speak here, there are issues in other areas, in other communities where, you know, squatters are up in arms. They're saying that the LSA is coming and they feel threatened. They're up in arms about their homes being destroyed, and they have engaged, been bulldozed, for want of a better phrase, and they have engaged assistance. They have gone to lawyers. They have engaged the MP's offices for assistance, without little or any sort of outreach coming from the AG's office or from the Ministry of Agriculture, Land and Marine Affairs. So, Mr. Deputy Speaker, I think it's quite hypocritical to state that, you know, we're coming with this piece of legislation and this would be the be-all and end-all in terms of solving that squatting problem. And I think that the Attorney General, who seems to be in touch a little bit in terms of knowing the realities on the ground, because he himself is an elected member of Parliament, would know that it's not going to be an easy task in dealing with regularizing and having these persons get their legal title to land. Mr. Deputy Speaker, let me remind the public that these pieces of legislation began in 2000 by the then UNC government. It is our bills, and therefore there is no intention, there was never any intention to not support these bills.
155(1)B, please. I'll invite you to look at it. Tedious repetition.
Again, member,
Thank you.
tie it in quickly.
Sure.
Make your point and tie it in very quickly.
Yes. So, Mr. Deputy Speaker, as I said before, and I'm responding according to the debate for the entire day, you know, being labeled as unpatriotic, not wanting to support and all that kind of thing. I mean, it is my duty as an elected member of parliament to respond to that, notwithstanding the time of the night. And, you know, I've sat here and I've listened to every single one of them throw their barbs back and forth, and it's my time now, so give me some leeway. So, Mr. Deputy Speaker, I just wanted to quickly raise that.
Standing Order 48-3, the member is reviving a past debate.
We are in the debate.
You can't do that. 48-3.
Member, you'll need to move on from that point.
All right, thank you, Mr. Deputy Speaker. Another very important point I wanted to raise and ask of the AG is about the issue of de-reserving forest reserves. Again, I make reference to, and I go back to the Section 3, where it is that I'm just saying that what is happening out there is that, again, going back to Clause 3, of the bill, where it is that the forest reserve is part of this, where it is that the state lands are not subject to bar on right of action. Whether or not it is true, Mr. Deputy Speaker, and the AG will be able to clarify this, that in this instance, the long stretch forest where the Komoto-Manzalina Highway runs through, whether or not this area has been de-reserved or was de-reserved before the project started as the highway.
Standing Order 48-1. The Act clearly states it does not apply to forest reserves.
Right. Honorable Member, we passed that stage already, and we asked, that was your first point, and we identified to move on.
All right. Thank you, Mr. Deputy Speaker. And I will, of course, move on. Mr. Deputy Speaker, in addition to that, I also want to state that with respect to Clause 4 and adverse possession, this has been a long-standing problem in our society with respect to getting legal title. Mr. Deputy Speaker, these squatting communities, as you would know, they are already in a position where they are very much challenged in terms of accessing state resources, basic amenities, light, water, you know, the social ills of society permeate through these communities.
Order 55-1.
I did not see. What is it?
Tedious repetition. I invite you to look at it.
Member, please. You made reference to that point already about squatters accessing Wassa water, tea and tech electricity. You made that point earlier just now already, member. So tie it in quickly and move on or go to another point.
Speaker, let me also state that, and for the purposes of getting clarification from the AG, I want to ask of the AG the process. How long is this process when started? Because the AG spoke about getting the loan from the IDB and setting up offices in Tobago and, of course, improving the land administration here in Trinidad and Tobago to speed up the process, to modernize the process. How long before, after passing these bills here tonight, we are going to see structures and mechanisms we put into place within these ministries to speed up the process of fast-tracking and moving forward to regularizing the squatters, to, of course, dealing with the land registry issues and other issues that fall under this package of land legislation? How soon before we see this taking place? Because people are expectant, they're extremely expectant. Some of them are very excited to hear that there are going to be groundbreaking changes taking place, land registry with respect to all of these bills that he has spoken so glowingly of and about and taken credit for. So, Mr. Speaker, we want to know that. We want to know a tentative cost, probably. How is it going to be budgeted? Is it going to be rolled out in phases? What is going to happen? Are we going to be employing, through the state, more lawyers, more researchers, more officers to go out there, gather information? We know that the issue with respect to Tobago lands are very important. There are a lack of resources and personnel across in Tobago. Who is going to be responsible with respect to employing the resources that would be necessary? What about the budgeting? What is the role of the THA in dealing with these land matters? What is their role? Because they are, of course, that is the governing body for Tobago and Tobago issues. So what is the collaboration and the relationship going to be like between central government and the THA in rolling out the plans that the AG spoke about? So budget, infrastructure, getting off the ground. How soon before all of this becomes a reality for the people of Trinidad and Tobago, Mr. Deputy Speaker? And with that, I conclude.
I recognize the Honorable Attorney General.
Thank you, sir. Thank you, Mr. Deputy Speaker. I thank the Honourable Member for Couva North for her contribution and for presenting the inquiries that she has laid on behalf of her party. I wish to address those in very quick measure. First of all, in respect of the question on de-reserving forest reserves, etc., and how this Act will apply, it does not apply. The Act specifically in Clause 3 of the bill, as we propose that it stand as legislation, says the Act shall not apply to land declared to be a protected area or forest reserve under the Forest Act. Secondly, the Honourable Member asked how do we propose to deal with people who are squatting and have the need for legal title. Well, the land package proposes that process to be dealt with, the registration of title to lands, the adjudication cycle. That package of legislation intends for that to be dealt with. But in any event, this Act is for simply the restatement of the existing law. This is law which has existed since 1898, Mr. Deputy Speaker, and therefore we are not proposing anything other than a simplification of the language and the amendment for the sensitive areas that are not subject to the legislation. Mr. Deputy Speaker, it was a most remarkable suggestion by my learned colleague to say that the Attorney General is giving no assistance to people who are squatting, essentially. Mr. Deputy Speaker, permit me to just read this, because, you know, the Parliament bothered to take time to print a hard-copied version of the Constitution of the Republic of Trinidad and Tobago. And Section 76 of the Constitution, subsection 2, reads as follows. The Attorney General shall, subject to Section 79, be responsible for the administration of legal affairs in Trinidad and Tobago, and legal proceedings for and against the state shall be taken, A, in the case of civil proceedings in the name of the Attorney General, B, in the case of criminal proceedings in the name of the state. I mean, surely my learned colleague must know that I am not permitted constitutionally to be assisting people in advice as to how to break the law. It just doesn't arise, Mr. Deputy Speaker, and the Honourable Member ought to know that. And to say that squatters are being prejudiced, etc., it's far from the case. What we propose by the laws that we are bringing to this Parliament is that we allow a cost-effective, independent, state-driven process by which adverse possession or squatting rights on private and state land can be dealt with. And what is amazing is that instead of the Honourable Member saying, thank the Lord that a government is taking this issue seriously and bringing a mechanism to help people, more questions are being asked about what we're doing than, in fact, are even relevant to this debate. Because this debate and these debates over the last few days have been squarely designed to assist people in difficult circumstances, Mr. Deputy Speaker. Mr. Deputy Speaker, The role of the THA is clearly defined under the legislation that treats with it. However, these laws operate independent from the THA's aspects. The system of regulation of title, the system of land adjudication, the system of the land tribunal, and the state limitation as this bill deals with, they stand separate and apart from that because these are the laws for Trinidad and Tobago. The honourable member asked what was the rollout plan, how is it going to be done, where we spent 2-3 days squarely treating with that issue in the various pieces of law that we have debated in this parliament. And we have said openly that there's IDB funding, there's counterpart government funding, and we intend to start in districts and areas, adjudication areas, as the law prescribes. I must remind that this law does not see the collapse of the Registration of Deeds or the Conveyancing and Law and Property Act, nor does it see the entire collapse immediately of the Real Property Act. What it does is that it allows for transitional provisions. Mr. Deputy Speaker, I think that that encompasses all of the responses to my learned colleague opposite. I recommend this law as good law, restated, simplified, and bettered law with legitimate aim and purpose, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Repeal and Replace the Crown Suites Limitation Ordinance be now read a second time. All in favour, say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Crown Suites Limitation Ordinance.
Attorney General.
Mr. Deputy Speaker, in accordance with Standing Order 68-1, I beg to move that the State Suits Limitation Number 2 Bill 2017 be committed to the Committee of the Whole.
Honourable members, the question is that the State Suites Limitation Number 2 Bill 2017 be committed to the Committee of the Whole. All in favour, say aye.
Aye.
Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Right.
Clauses 1 to 6.
The question is that clauses 1 to 6 stand part of the bill. The question is that clauses 1 to 6 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 6 now stands part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Thank you, members. The Attorney General.
Thank you, Mr. Deputy Speaker. I wish to report that the State Suits Limitation Number 2 Bill 2017 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the State Suites Limitation Number 2 Bill 2017. All in favour say aye. Aye. Any against? The ayes have it. The Attorney General.
Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Repeal and Replace the Crown Suits Limitation Ordinance be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Repeal and Replace the Crown Suites Limitation Ordinance be now read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Repeal and Replace the Crown Suites Limitation Ordinance.
Leader of the House.
Mr. Deputy Speaker, I beg to move that this House do now adjourn to Friday, the 23rd day of March 2018 at 1:30 p.m. That day is private members day, and I would ask the Chief Whip to inform us what we would be doing.
Chief Whip.
Deputy Speaker, we'll be continuing motion number 1 by the member for Shogunas East.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Order 11 and 12(1), this House now stands adjourned to Friday, the 23rd March 2018 at 1:30 p.m.